It is a personal joy for me to be here with you. Let me explain why it is such a joy. I spoke yesterday at another group in Fort Worth, in North Fort Worth, where I had to be careful because of the audience as to what I said. Here, I feel I can say what I fundamentally believe in my heart. That is a wonderful freedom that we share together as a congregation. The freedom to seek, to understand, and to speak our minds. We should cherish that, especially as we come into our stewardship season, because we owe this congregation a lot. We owe, in many respects, we owe one another our personal freedom. So I'm going to be talking this morning about freedom, and I should begin by explaining when we're talking about the right to marry. It was recognized in 1965 for some people, but not for everyone. We'll be talking during the next few minutes about a decision of the United States Supreme Court that will be made this coming June. My prediction is that there will be at least 5 votes cast by the Supreme Court of the United States in June in favor of the right to same-sex marriage. Let me explain what I mean by right. I've been doing civil rights and liberties for many, many years, and one of the reasons I did it in Texas is I did not need a majority to prevail. I once was a covert agent of a group sent to a rally by our Governor Rick Perry when we were trying to amend the Constitution to prohibit same-sex marriage. And I was quietly in the back of the room listening to what they said. And there are a lot of folks out there that don't agree with what I'm about to say, and in fact, they are indignant, outraged, and insistent on a contrary point of view. But if the Supreme Court rules that it's a fundamental right to marry, everyone will have that right, and majorities cannot stifle or interfere with that right. And that's a fundamental and important achievement. So, I'm going to be talking not about gloom and doom, which is what I try to avoid when I read the paper in the morning. Oh my God, gloom and doom again. I'm going to talk about positive things that have happened in this country, and we have now a prospect of doing even better. We've come a long way toward respecting the dignity and equality of all persons. But now we have an opportunity to extend our freedom. So let me review for you our previous efforts quickly. I have enough time to do this because this is the second time I've done it this morning. Okay. So, in March of 1857, the Supreme Court of the United States, in one of the events leading up to the American Civil War, wrote, you're going to find this hard to believe, that once this was written by the Chief Justice of the United States, Roger Taney of Maryland, who announced that slaves were not citizens of the United States and therefore had no rights that they could protect in federal courts. And I quote, they had no right which the white man was bound to respect. They were mere chattels. A terrible word. Chattel is a piece of personal property, the personal property of their owners. Slaves were not people to be respected under the law. So wrote the Chief Justice of the United States in 1857. It took us about 100 years to get rid of some of the most serious stains of slavery and racism in this country. and we're not there yet. Gender. In 1873, an opinion by Mr. Justice Bradley of the Supreme Court, Myra Bradwell was denied the right to become a member of the bar, to be a lawyer in the state of Illinois. Not because she wasn't qualified, she had passed the bar and she was well qualified, but she had no right to practice law because she was a woman. I can't do this without smiling, I apologize. Bradley wrote, you'll see why. Okay. The natural timidity and proper timidity and delicacy which belong to the female sex evidently unfits them for the occupations of civil life. It's worse. The paramount destiny and mission of women are to fulfill the noble, you got that? Noble and benign offices of wife and mother. Okay. This is great. Okay. This, he wrote, is the law of the Creator. So in 1873, women had not only the Constitution against them, they had God himself, herself, arrayed against them. And it took us until 1971 to get rid of that quote. Okay? Sexual orientation. Do you recall, perhaps you don't, there's no reason why you should, we used to have laws against lots of things that we now think, my God, why did we do that? We have laws against fornication. We have laws against adultery. We had laws that described a variety of sins involving human contact that were felonies and that could lead sometimes to, if you can believe it, to capital punishment. You could be executed for adultery. Can you imagine that? Okay. In 1986, in the case of Bowers versus Hardwick, the Supreme Court ruled that any idea that there was any kind of right of homosexuals to engage in sexual conduct with one another was not bound by any decision or precedent of the Supreme Court of the United States. So, homosexual conduct, sexual conduct between men or women could still be prosecuted as a felony, as a crime, in 1986. 17 years later, in a case from Texas, surprisingly enough, the Supreme Court ruled that there was a constitutional right among consenting adults to engage in same-sex activity, and that it was protected by the Due Process and Equal Protection Clause of the Constitution of the United States. So, it may well be true that the long arc of the moral universe tends toward justice, as was said both by Reverend Theodore Parker and by Reverend Dr. Martin Luther King, but there still remains before us the question of same-sex marriage. The case will be argued on April 28th and decided by the Supreme Court sometime probably in June. Here's my prediction. You can hold me accountable for this. At least 5 votes, probably 6 votes, in favor of the right to marry regardless of one's gender will be upheld by the Supreme Court of the United States. And that means every person in the land will have a right to marry whomever they like, and no one, no matter what majority is arrayed against it, can take away that right. So, how do we get there? It's an evolutionary process. We develop better ways of understanding and having compassion for the people around us as time goes by. We can be proud and should be proud of our progress. So I'm going to tell you 4 love stories quickly. An opportunity to revive and raise our compassion for all people. First, the love story of Mildred and Richard Loving. Mildred Loving was a black woman, and her husband, Richard, was a white man. They lived in the backwoods of Caroline County, Virginia, and their marriage came before the Supreme Court of the United States in 1967 because the Commonwealth of Virginia still had a law against, here's one of those old words, miscegenation, okay, against interracial marriage, okay? Central Point, Virginia, where they lived, had long been a mixed-race community in the backwoods of Virginia. They worshiped together in St. Stephen's Baptist Church, which was the largest mixed-race church then in that county. But the laws of discrimination were still on the book. By the time that Richard and Mildred began to date in the 1950s, they had lived in a community that had evaded Jim Crow laws in Virginia for many years. But someone complained and said they're violating the laws of the Commonwealth of Virginia. And their case reached the Supreme Court in 1967. And its ruling was that any laws passed by any state to prosecute persons for interracial marriage were unconstitutional as a denial of equal protection of the law. That's 1967. Let's run the clock forward to 2013. And I'll tell you the love story of Edith Windsor and Thea Spire. In 1969, Edie Windsor met Thea Spire at the Portofino restaurant in Greenwich Village. I've been there myself. Very fine restaurant. Edie was a 34-year-old computer programmer and divorcee who was eager to find companionship. Thea Spire was a PhD clinical psychologist. They danced through the evening and decided to start dating. And 4 years later, Thea proposed a union. They moved in together near Washington Square. And they traveled together a lot and proudly marched for civil rights and others. But in 1977, Thea Spire, who was then 45, was diagnosed with progressive multiple sclerosis. And Edie became Thea's full-time caregiver. In 2007, Thea's doctor warned that she had but 1 year to live. And the very next day she asked Edie, "Do you want to get married?" Edie's answer was yes, and they flew to Canada, where they were married by the first openly gay judge serving in Canada. Edie was 77 and Thea Spire was 75. But 2 years later, Thea died, and Edie suffered a heart attack, which was supposedly the result of a broken heart syndrome. When she recovered, she discovered that the federal laws respecting the estate that Thea left meant that she could not be recognized, even though she was lawfully married in Canada, she could not then be recognized as a lawful surviving spouse. So she was expected to pay several $100,000 in federal estate taxes. Okay? Why? That's because, I got it here in bold and with quotes, I love this quote, the guardians of marriage. Who are the guardians of marriage? Who were the guardians of marriage? They were the guardians of marriage in our Congress that had passed the Defense of Marriage Act, limiting marriage to a marriage between a man and a woman. And to make it bipartisan, that act, the Defense of Marriage Act of 1996, was signed into law by President William Jefferson Clinton. Edie filed suit, and the Defense of Marriage Act was declared unconstitutional in 2013. Justice Scalia, one of the most conservative justices of the court, warned that this day would be coming. And the day that is coming are the cases that will be argued by the Supreme Court on the 28th of April. So let me tell you two more love stories. The love story first, April DeBoer and Jane Rouse. April and Jane, both from Michigan. They sued in 2012 to challenge Michigan's adoption laws, which prevented them from both adopting the special needs children that they had cared for as a couple. They each had adopted children as individuals, but they could not adopt together because Michigan did not recognize their marriage. When they tried to put their legal affairs in order, they learned that if under Michigan law, if one of them died, the other would not have any custody rights with respect to the children that they had individually adopted. So they decided to challenge that adoption law, and that became a challenge under the Equal Protection Clause to their right of marriage itself. Let me tell you the love story of James Obergefell and John Arthur from the state of Ohio. When John Arthur died, the state of Ohio would not list James as his spouse on the death certificate. And the suit against the state of Ohio for the recognition of their marriage on the death certificate was joined by the funeral director who was responsible under Ohio law for issuing those death certificates. The story of John and James, both of them were 47 when they married. John was dying of Lou Gehrig's disease, and their friends and family had donated more than $13,000 for them to fly to Maryland in the summer of 2013 in a special jet equipped to take care of the ailing member of that partnership. They were married on the tarmac at the airport before they returned to Cincinnati, where they lived. They sued the state of Ohio to recognize their marriage and to recognize their union during their remaining days, but John died before that could happen. So James carries the case forward before the Supreme Court of the United States. So I've given you two cases, one from Michigan and one from Ohio, both involving intimate, wonderful, supportive, caring relationships that the Federal Circuit Court for the Upper Midwest, the Sixth Circuit, upheld the laws of both Michigan and Ohio and said that there was no right to same-sex marriage. There are other parts of the country, as you may have read in the newspaper, that have declared that there is a constitutional right to same-sex marriage. We have 12 federal circuits, so we're broken into divisions across the country according to where we live. We're in the 5th Circuit. The 5th Circuit has not yet ruled, but there is a case pending there. But what we have is some federal circuits that uphold the right to same-sex marriage and others that uphold the rights of states to prevent it, as supported by our former governor, Rick Perry, and most of the establishment in the state of Texas. Okay? So that's called inter-circuit conflict. There is only one court in the land that can resolve that conflict, and that's the Supreme Court of the United States. And they will hear the arguments from the 6th Circuit and other circuits on the 28th of April, and the Supreme Court will decide their case probably before July 1st. So there are 2 questions before the Supreme Court that will be decided this summer. One, which would take care of the whole area if they decided this, whether a state's prohibition of same-sex marriage violates the Equal Protection Clause of the Constitution. If they decide that it does violate, then it's all over. There can be no state, regardless of the majority, regardless of a constitutional amendment, as we have in Texas, or regardless of a regular statute by majority of the state legislature, there can be no laws proscribing same-sex marriage. That's the first question. If they decide to do contrary on the first, then the second question would arise, and that is whether a marriage that is lawful in one state is entitled to be recognized if the couple moves to another state. We could have that decided independently of the fundamental right to marriage. But the outcome will depend on, this gets technical, what standard of review the court will use in assessing the right to marry. Let me describe that quickly for you, and then I think it will be very, very clear. Usually we have laws passed by state legislatures or by Congress based upon the principle of a majority of those chambers. Simple majorities usually, sometimes extraordinary majorities, sometimes 2/3. And mostly the Supreme Court defers to those if they can find any rational purpose at all. The court is required to uphold that legislation. So under that lowest level standard, the rational purpose test, if the court finds a rational reason to prohibit same-sex marriage, the court would be required to uphold it. But that's only the lowest level. The next level up, the one that applies to women, to gender, actually applies to both men and women. It's across the board. It's called heightened scrutiny. In 1971, overturning the case of Myra Bradwell back in 1873, in 1971, the Supreme Court of the United States said, laws respecting gender are entitled to greater scrutiny. Okay? And that means that a state law must have an important public purpose to be served, and the laws must be narrowly tailored to restrict personal freedom as little as possible. Okay. Now, we still have heightened scrutiny with respect to gender. That's because there are some laws that recognize differences between men and women that are appropriate. Does that surprise you? If you think about it, it won't. We have, for example, a Pregnancy Discrimination Act. Okay? Saying that employers cannot discriminate against their employees because they're pregnant. Not terribly well enforced, but it's on the books nonetheless. Okay? So, with gender we have heightened scrutiny. So that means that you can get some things through, but they have to represent the biological/genetic differences between men and women. They cannot recognize, I love this phrase, the court has used it a number of times, they cannot recognize what are called archaic and stereotypical generalizations about the proper role of women. When I read you about Mara Bradwell, a natural timidity and delicacy, that's an archaic and stereotypical. So the next level up is called strict scrutiny, and this is what I think will happen this summer with respect to sexual orientation. Is there any legitimate public interest in limiting marriage to that between a man and a woman? Is there any? I don't think there is. You may know we live in a state where there are lots of people who think otherwise. That's why we should be grateful for this congregation, because I suspect most of us here think stupid. Okay? And if we have strict scrutiny applied to sexual orientation, that would say there can be no laws that treat people differently because of their sexual orientation. Okay? No laws. Strict scrutiny means that any state law that prescribes different rules or outcomes based upon your sexual orientation would be, you got this, presumptively invalid. That means that the burden of proof is on anyone who would try to justify such a restrictive law. And I don't think there are any such restrictive justifications. I think probably even in Texas, biblical justifications don't meet the legal test. So whether you're talking about the book of Romans or the book of Leviticus, I don't think that is sufficient. So I suspect, and here's my prediction, there will be at least 5 votes, almost certainly including Justice Anthony Kennedy from California, who's at the middle of the court, and I think possibly including the Chief Justice of the United States, John Roberts, to hold same-sex prohibitions to be unconstitutional. I think that is coming. I think that's likely to be the law of the land. And I think that progress is a great thing. All the women present should know that if we go back to what was meant when the Equal Protection Clause was written in December of 1865, the congressman who wrote it, John Brigham of Ohio, was asked the question on the floor of the Congress, does equal protection apply to women? And he said, oh, no, it doesn't apply to women at all. We knew it didn't apply to slaves, it didn't apply to blacks, it didn't apply to women, so guess what? Equal protection was for men only. And those days are now more than 100 years past, and it took us, I said, 1971 to apply equality to women, to gender, and I think now we have the opportunity to apply it to sexual orientation. I'm almost done. The one we have yet to deal with, which is going to be really interesting, is transgendered rights. And within 2 or 3 years, that's going to be before the court as well. And how shall those people be regarded under the law as respecting their dignity and personal freedom? So, I'm going to do something I don't often do. You can smile with me as I say it. I think we have come to a point where we can say